Welcome to Lawyered. I'm Hussein Panju. This is part 2 of our interview with military lawyer Colonel Michel Drapeau, who will speak about Bill C-77 and the modifications to the summary trial process. To hear the rest of this interview and for interviews with other lawyers, please check out lawyeredpodcast.com or follow the show on your favorite podcast app. In the year 2019, the era of military law saw a significant overhaul through the introduction of Bill C-77. Amongst other things, this bill has transformed a portion of the military adjudicative system into a non-penal, non-criminal summary hearing process. And while the impacts of Bill C-77 are still yet to be seen, this triggers a number of other issues involving the appropriate way to discipline service members within the armed forces. So, Michel, I know that this bill is quite complex, and we won't talk about all the aspects of this, but before this bill was introduced, can you explain the two types of court procedures that were operating in the military context?
Yeah. What I'm about to tell you exists as we speak. Okay? So there are two sets of service tribunals. One is a court-martial, and then there are summary trials. To give you an order of magnitude, there's roughly 60 court-martial a year. There are about 800 summary trials a year. And it varies from years to years, but it's a high number of summary trials. And the judge will eventually convene the court, and the court will take place fundamentally with the same process as you would find in civilian court. The court also has its own rules of evidence and rules of procedure, which are akin to what you'd find in civilian process. So I have no difficulty when it comes to procedural fairness with a court-martial process. The court-martial process is fundamentally the same as you would find in criminal court. So the military police would do an investigation. If they feel that there is sufficient evidence, they will lay a charge against the individual. It will go to the director of military prosecution, who will perfect the charges being laid on the presumption that there is sufficient evidence to bring about a conviction. Once this happens, a court-martial will be convened. Summary trials are as unconstitutional as they come. Why do I say that? The president of the summary trial is a commanding officer. And the summary trial tries disciplinary issue and quasi-criminal or criminal offenses. Stealing, arson, desertion, abuse of subordinate, being absent without duty, unsafe operation of a vehicle, a weapon, or whatever, and so on. So the commanding officer, he tries these issues. At trials, you have no right to counsel. There are no rules of procedures. Hearsay and spousal privileges apply. There is no appeal, and you can be sentenced to detention, and you have no appeal. You have an ability to ask that the judgment be reviewed by a superior in the chain of command. That's it. This has been declared by the European Court of Human Rights as being improper and contrary to the European Code of Human Rights. Most common law countries have created, in fact, a process that is now more akin and more in concert with human rights. So the previous government in 2015, just before the 2015 general election, passed a bill that changed the summary trials. It died on the order paper. And when the Liberal government, this one, got elected, it introduced exactly the same bill, Bill 77, which was enacted into law in June 2019, that does away repeal summary trials entirely.
How does Bill 77 change the hearing process? So you said before we had the summary trial process and the court-martial process. So what does Bill 77 say should happen?
77 took the teeth out of it. You can no longer be sent to detention. You have no longer a capacity to have a criminal record. You are no longer without any rights to to have an appeal of some sort and so on. It's purely an administrative disciplinary process, as you would find throughout civil society. So if you're late, or you've been insubordinate, or you've been whatever, and it has to be dealt with on the disciplinary matter, your boss, your employer, may give you a fine, may give you suspension, may give you a reprimand, but that's the end of it. You are not facing a trial per se. You can no longer be convicted. There's not a record of it. It addresses the unconstitutionality of the former system. So now you are facing the same workplace discipline standards that you would find with any other employer in Canada. End of story. So it is significant. It decriminalized the process.
So we have this bill that's been introduced, and where does this stand right now in terms of implementation?
It's not enforced yet. It is still sitting on the books and the only reason provided is that they're drafting regulations. So meanwhile, as we speak, since 2019, we still have members of the military on an ongoing basis facing a summary trial, despite the fact that Parliament has spoken.
So if you're a military lawyer and you have a client who's called before this summary trial, what are some things that you would think about in terms of your strategy? Like, is this something that you could use in your advocacy?
Yes, we have. And where we find such cases, if the members, particularly because of the alleged gravity of the offense that he or she being charged with, we normally advise the accused to elect for a court-martial, so that even if the offense on the surface of it appears to be of a summary nature, he has no rights whatsoever in a summary trial. So we advise him to proceed at court-martial. And then it all depends whether or not the military justice system will in fact decide to carry on with the court-martial and use the judicial resources for that aspect. But there's no other avenue except to wait.
So when eventually this bill is implemented, what do you think the impact of this will be? Because speaking from someone who has no background in the specific area of law, I would imagine that would mean that more offenses may be heard by way of the court-martial process than under the status quo. Is that what you think as well?
Yeah, I think this may happen, but I think it rebalances the power imbalances in the military, particularly where you have the rank and sometimes the isolation, particularly if a unit is deployed in Ukraine or Afghanistan or whatever. You don't have any civilian oversight or access to civilian counsel if you wanted to, or your friends or family or advisor and so on. So it will create a better balance between the individual soldiers and the chain of command, where they would think long and hard before just abusing, for instance, a charge under the Code of Service Discipline that goes to a court-martial, because ultimately there will be a day of reckoning. The court will take place, a defense will be provided to the accused, and then if there were to be an abuse of process, that will come to light. I think it's a simple recalibrating, and we're doing in Canada what a number of other countries, allied countries, have done, I think, for the good.
Our guest for today was Colonel Michel Drapeau, and you can learn more about him and his law practice at their firm's website, which is mdlo.ca, which stands for Michel Drapeau Law Office. So that's mdlo.ca. And for more about today's show, and for links to all the cases and statutes and bills that we spoke about today, you can find all those on our website, which is lordpodcast.com. Next time on Lord, we'll be speaking about data protection law with leading expert Chris Klein. Chris is a lawyer whose name is basically synonymous with Canadian privacy law, and amongst other things, Chris is the managing director of the International Association of Privacy Professionals. So we'll be doing a deep dive into some of the recent legal issues involving data protection, including facial recognition technology, the Facebook Cambridge Analytica scandal, and we'll also be finding out about the most consequential piece of privacy legislation in over 2 decades. And as mentioned, if you really want to help to improve this show, and get some really cool, affordable legal rewards, like the opportunity to submit questions for our show, early access to other episodes, and a bunch more things, the very best thing you could do would be to become a patron of our show. You can find out more about how to do that and what that means on our crowdfunding website, which is lordpodcast.com/patron. That's lordpodcast.com/patron. We want to give a shout out to a bunch of our patrons, including Brian Osler, Jeff Langweir, Karen Gottfried, and Mohan Pandit. Thanks to everything that you do to make this show as great as it is. Our sound editing work was managed by Solomon Kraus-Imla, and our theme music was provided by Ben Swirsky, and our website was maintained by Steve DeMello. And special thanks to Steve. Over the last few weeks, we had a bit of a scare in terms of some of our edits, but really appreciate you coming to the rescue to make that work. And finally, please be advised that while the show is aimed to be helpful and informative, that it is not legal advice. However, if you do want legal advice, please reach out to a lawyer directly to help you with your particular situation. And with that, we will see you in 2 weeks. Until then, keep it legal.